Good morning and welcome to Sound Bites with Mobile Legal. We're in the midst of the COVID-19 stay in place or voluntary stay in place, and hopefully you all are, to keep yourself safe. And we thought we'd take today's question outdoors. Today's question is going to be a two-part series around debt verification. First of all, requiring verification is one of the easiest and most important tools that the Fair Debt Collection Practices Act, FDCPA, gives you in responding to third-party debt collection attempts. So what is verification exactly? Well, it's simply a formal step that requires third-party debt collectors to validate that you are the correct person who owes this debt and that the debt itself is valid. So when do you verify? Generally, this is going to be in response to either a phone call or a letter that you've received in writing. If a debt collector has called you through the phone, as you remember, we're never going to settle with them on the phone. We're not going to provide them financial information over the phone. We're going to ask them to send in writing. You're also going to ask them to stop calling you. Another important note, and why we keep a log by the phone for these debt collection calls, is that within 5 days of that first hello telephone call, the call they're trying to collect the debt, they need to send you a written request, dunning letter, a hello letter, in the mail. If they have not done so, this is an FDCPA violation. Now, if they have sent it to you in the mail, what are we looking for? Well, there should be a few things. One, they should identify your name, your address, last 4 digits of the account number of the current holder of the debt, and as well as their account as well. But you're looking for a few statements that the FDCPA requires. The first statement is going to let you know that if you do not dispute this debt within 30 days, they have a right to assume it's valid. You don't want them to do that. That gives them the right to move forward to start litigation against you. They also need to tell you that if you do dispute the debt within 30 days, they need to stop and cease all further collection activity until they validate that debt. Lastly, they should be letting you know that upon request, they need to provide you the name, address, information regarding the original creditor of this debt. So you want to look for those things. I would keep a copy of this letter. Look to see if they specifically gave you those pieces of information, because if they did not, these are violations of the FDCPA, and this is going to give you leverage for the future. Okay. So why should you verify? Well, there's really two reasons. First is you might incite them to just stop reaching out to you. They're looking for the low-hanging fruit. They want to look for the debtor who's not going to respond to the letter and likely not going to respond to any future lawsuit. This is going to be an easy win for them. They'll get a judgment against you, and they'll be able to start collecting and garnishing your wages or your bank account. And I've heard some clients say that once they've sent this letter, they've never heard from them again. That's not uncommon, and that's good too. And that's going to lead to our Part 2 series of what you do then. Now, the second reason is they often ignore the law. They might continue with collection attempts. It might be a few weeks from now, it could be 6 months, it could be a year later, but they continue without ever validating the debt. That is a violation of the FDCPA. That's going to give you leverage power. So again, this is why we want to keep record of not only the phone call, but the letter in writing and any response you provide to them. So this sounds great. How do I verify it? Well, as always, I'm going to recommend you reach out to an attorney. If you don't know of one, you can contact your local bar association. Florida has a referral service through their bar association, and you can ask them for the name of 1, 2, or 3 attorneys. Contact those attorneys. They may help you with this dispute at no upfront fee. And you're probably wondering, why would they do that? Well, the same FDCPA rules that protect you provides payment of attorney fees by the other side if they violate those rules. They do this often, and they don't often respond to disputes. So this is giving an incentive to attorneys to help you with no cost, because you're probably going to end up needing to sue them, and the attorney will then get paid by the other side. Now, you've heard the advice, but you want to proceed anyway on your own. Proceed with caution. Be careful that you're not giving them any information it can help make yourself a bigger target than you already are. You don't want to provide them any information about why you've got into this state of default. Just ask them to provide you information. And what you're going to ask them for is you're going to ask them to verify the debt. You want the name, information regarding the original debt holder. You want them to show that they have a right to collect on the debt and that the debt is truly valid, as well as the amount. Remember, the debt collectors, third-party debt collectors specifically, are looking for the easy win. By you responding and using the tools that are available to you, you might encourage them to go away. Go continue seeking the debt against somebody else who's not going to stand up for their own rights. Again, if you have any questions, reach out to Mobile Legal or an attorney that you know and trust. You can hit the subscribe button below so that you're sure to be notified of any future videos that might be of importance to you. And as always, we wish you and yours financial health.